Everybody, welcome. Again, I can't see you, but I know you're out there. Before we start, we would like to acknowledge that we are on the shared lands of the Musqueam, Squamish, and Tsleil-Waututh nations, who have stewarded this land for many years in the past, and that we look forward to working with them constructively and positively in the future. I'd like to introduce Andrew Robb, who is the lawyer at Disability Alliance BC. He's a staff lawyer at the new Disability Law Clinic that was started there last year with funding from the province and the support of Law Foundation BC. So a great resource, which we're glad to get you to know about through watching Andrew's presentation. But because Andrew has a longer background in sort of general poverty law, he also volunteered to do a workshop on foreclosures. I'm going to let Andrew introduce himself and talk about his topic just going forward. I just want to note that, as I said in the chat, please put your questions in the Q&A. We'll watch for them throughout and pose them to Andrew. We won't use names in case there's any issues of confidentiality. And if you have any problems with connectivity or stuff, put that in the chat and Nikki and Kate will help figure that out. Okay, thank you, Andrew.
All right, well, thank you very much. I did also want to acknowledge that I'm also on the traditional, ancestral, and unceded territories of the Musqueam, Tsleil-Waututh, and Squamish peoples in what we now call Vancouver. As Lois said, my name is Andrew Robb. I use he, him pronouns. So as Lois also said, I am the staff lawyer at the Disability Law Clinic at Disability Alliance BC, which has just opened in the last few months. If you were at the presentation a few weeks ago now about the new law clinics, you might have heard me say that I don't do a lot of work in the area of landlord-tenant law, and that's still the case. However, I had just one file a few months ago, and you might know how this works. If you get one file in a specific area, you have no choice but to learn a lot about that area. And so there was one file I had to work on that involved a person who was in a residential tenancy where her landlord was being foreclosed upon. And so it happened that I learned a lot about this topic. But I should add that, as I said, the law clinic is a new project, and I just moved to BC to start this project. My experience before this was mainly in Alberta. And I did do a lot of landlord-tenant work in Alberta, but as you probably know, residential tenancy law is one area that tends to change a lot from one province to another. And so I am not by any means an authority or an expert on landlord-tenant law and process here in British Columbia. I have picked up a few things, but there's still a whole lot that I have to learn. And so today, I hope that I've got the procedure right for the purpose of this presentation. I think I know what I'm talking about, but I guess we'll see. And I am open to anyone correcting me if I get anything wrong about the finer points of residential tenancy law here in BC. Yeah, so I think that's what I wanted to say by way of introduction. Can we go to the next slide, please? So this first slide here is the objectives, and this is both the objectives of my presentation today and also the objectives that I believe you should have in mind when you are dealing with a person in this situation. In other words, a residential tenant whose landlord is being foreclosed upon. And I should say right off the top, unfortunately, in almost every case, there is nothing you can do to stop this process. When your landlord is being foreclosed upon, bottom line is, at some point, probably not too far away, you're going to have to move. In a foreclosure case, the bank or the lender has a huge amount of money on the line, whatever the value of the property is, usually in the hundreds of thousands of dollars. And so they take it very seriously, and they hire very experienced and very well-resourced lawyers who in turn hire very experienced clerks and paralegals who in many cases don't do anything else. In many cases, the clerks and paralegals do nothing but foreclosure work all day, every day. And so they know what they're doing, and they don't usually make mistakes. I'm not saying they never make mistakes, but they don't usually. And so you should not assume that there is much that you can do to stop the foreclosure process or stop the effect it's going to have on a residential tenant. And so as it says here in the slide, I think the objectives I want to focus on today and the objectives that I would urge you to focus on if you are assisting a person who finds himself in this situation, first of all, make sure there are no surprises. You want to get as much information as you can about what's going on as soon as possible. And in some cases, if it's proving difficult to move, and I know, of course, that it's not an easy thing to do to find a new place to live and move out on a timeline that is imposed on you by someone else. But in some cases, you need to try to get more time. So the other objective I'm going to focus on is to get as much time as possible to find new accommodations if that's what the person has to do, if that's what the client or the tenant has to do. Next slide, please. All right, so these are the topics I want to cover today. And as I was just telling Lois before we started the presentation, I don't really have 2 hours of material here, and Lois told me that's fine. I think everyone at this point is prepared for a somewhat shorter presentation. So I'm confident we'll have ample time for questions if there are any. But I'm going to start by just setting out some definitions of various terms that I'm going to use here and terms that you might use as part of the, with respect to the foreclosure process. Then I'm going to give you a general, very simplified overview of what that process looks like and what steps need to be taken by the party that is seeking foreclosure. I will also talk about the legal rights of a tenant in a situation where the landlord's being foreclosed on. And frankly, there's not many legal rights to speak about, so that will be a brief section. But the tenant does have some practical options, despite a relative lack of rights in this situation. The tenant does have some options, and there's some things they need to know. So I will try to address what the tenant's practical options are as well. I have a section on how to try to delay the eviction in the event that the tenant needs more time to try to find a new place to live and move out. And as I will discuss in that section, there is only a limited number of things you can do, but there are a few options that are available in that situation. And then finally, I will give you some links to further resources about this topic. And as I said, I'm confident that we'll have time for questions at the end of the presentation. All right, so for the first section, I just want to go through a few definitions of terms I'm going to be using here today. And I should start by saying, as it says there, when I'm referring to a tenant in this presentation, just for the purpose of this presentation, that doesn't necessarily mean a tenant within the definition of the Residential Tenancy Act or the MHPTA, whose full name I can't recall right now. Those people might have more rights than others, and I say might because it's not clear that they do. But for the purpose of this presentation, a person can be, the people who I'm talking about as tenants are really anybody living in a property they don't own. So even if they don't fall within the definition of tenant within the RTA, for example, if they're in a roommate situation, or if they are merely in a sort of short-term accommodation situation, it might even apply. So I realize that is not a complete definition of tenant, but for the purpose of this presentation, I'm trying to keep it simple. So it's really anyone who's living in a property that they don't own. And I should add too, as you see after tenant, I put a big capital T in brackets. And that is just to say that in the slides, wherever you see me use a capital T, I am referring to tenant, and that's just an abbreviation that I use for simplicity's sake. And if there's anything that's unclear, please say so I think it would be in the Q&A, and I will do my best to make it more clear. And I also just saw Lois's note in the chat that there are a few lawyers watching, and I'm glad you'll get CPD for this, but as I said, I'm really focusing on sort of a rough and ready guide to the practical options a tenant has. I hope that I've got the law right, but I stand to be corrected on that. And if I do get anything wrong, please don't hesitate to let me know. The next definition I want to give is just a mortgage. I suspect that most of you all know what a mortgage means, but just to make sure we're all on the same page here, what I'm referring to as a mortgage is just a type of loan agreement, basically a contract in which a debt is secured by real estate. And you often hear these terms mortgager and mortgagee, and I've defined them here, but honestly, I can never remember which is which. Whenever anyone uses either of those terms, my first thing is to go to Google and look up what does mortgagor and mortgagee mean, because I can never remember which is the bank and which is the homeowner. In this presentation, instead of the term mortgagor, I will be just saying borrower. And instead of saying mortgagee, I will be saying lender. And as it says there, in most cases, the lender is a bank. It could certainly be some other kind of financing company. It could even be an individual, if it's an individual with a lot of money who is willing to give out loans. But you will probably find that in most cases, the lender in a mortgage is a bank or some other kind of finance company. The borrower, for our purposes here, is usually going to be a homeowner. Again, it could be an individual or a corporation. The main thing is it's the individual or a group that is the legal owner of the land at issue and has borrowed money from the lender, which is secured by that land. And I should clarify, when I say secured by, maybe I'll get to that in a few minutes, but I mean, the security is really the key thing here. Security for a loan means what the lender takes if there is a default on the loan. And I'll discuss that more in just a moment. All right, so a few more definitions here. In the context of talking about a mortgage and foreclosure, the word redeem has a particular significance. To redeem a mortgage means to pay the full amount of the mortgage debt in accordance with the mortgage agreement or a court order. And the word foreclosure itself refers to the termination or closure or foreclosure of the borrower's right to redeem the mortgage by paying the debt. In most cases, your mortgage agreement will tell you how you can redeem the mortgage. In other words, how you can pay off the debt and get the mortgage discharged. In some cases, when you're going through the foreclosure process, a court order will tell you how you have to do that. And in most cases, until the date of foreclosure, the borrower always has the right to redeem the mortgage. They might have to pay a penalty or they might have to go through a certain process to do that, but they usually have the right to redeem the mortgage and thereby get it discharged. However, when a property is foreclosed upon, that means that they no longer have the right to redeem the mortgage. And again, I'll talk more in a few minutes about how that actually happens. And one other term I'm going to be using is the term equity. And that's another one that I suspect that most of you are familiar with. But for our purposes today, basically what it means is the value of the property minus the amount owing on the property. And that is, again, that is maybe not the most precise definition, but I think it's going to work for the purpose of this presentation today. So now I'm into my section about the foreclosure process itself and what happens in a foreclosure. And so as it says there, if the borrower defaults on the mortgage agreement, the lender may take steps to seize or sell the property that was used to secure the loan. And the type of default that most commonly leads to foreclosure is failure to make payments as they come due. But there may be other forms of default, such as a failure to pay taxes on a property or a failure to insure the property. And basically what default means is some kind of violation of the mortgage agreement. The mortgage agreement probably, in most cases, includes many obligations that are binding on the borrower. And if the borrower fails to comply with any of those obligations, it may constitute some form of default. But lenders will generally be reluctant to foreclose unless there is no other way to make sure they get paid. So obviously, if they're not getting paid their payments as they come due, that is a good reason for them to foreclose. But if there's any other kind of violation of the mortgage agreement, most of the time, the lender will try to work with the borrower to keep the mortgage in place, because even if the lender has the right to foreclose, it is a lot of work, it costs money. It's not something that the lender wants to do unless it's the only way that the lender is going to get the money back that they loaned in the first place, or at least get as much as possible of that money back. But even in a situation, as it says in the slide, even in a situation where it's clear that the borrower has defaulted, where, for example, if the borrower simply stops making any payments at all on the mortgage, the lender must usually, and there's a typo in the slide, it should say the lender must usually obtain multiple court orders in order to seize or sell the property. And so this slide shows an extremely abridged, extremely simplified version of the foreclosure process. If a lawyer is actually representing a bank or lender in a foreclosure, the Law Society provides a checklist of all the steps you have to go through, and it's many, I can't remember the number, but it's many pages long. Like, there is a huge number of steps that need to be complied with in order to do the foreclosure process right from the lender's perspective. But this is a simplified version of it. It starts with the lender has to file a document in the BC Supreme Court called a petition for foreclosure. The lender would then have to notify the respondents. And the respondents will certainly include the borrower, and it should include anyone living at the property, such as a tenant. It should include that, but I'm going to discuss in a few minutes, there might be a chance it does not include the tenant. But in any event, the lender has an obligation to notify anyone who is named as a respondent in a petition for foreclosure. The next step after that is usually that the lender applies to the court. And anytime you see BCSC in my slides, I'm just referring to the BC Supreme Court. The lender has to apply, first of all, for the order nisi. I think it's nisi. Someone else might be able to correct me. It might be nici. Anyway, it's a Latin term, which I'm not really up in my Latin. But it is the general term for usually the first court order in a foreclosure process. And it is a very important court order because it sets out the redemption period. And so this goes back to that definition of redeem that I provided earlier. So it tells the borrower how much time they have to redeem the mortgage. And finally, if the borrower does not redeem the mortgage, in other words, if they do not pay off the debt in the time set out in the order nisi, I'm not sure, then the lender can apply to the court for a further court order. And this would be basically the final court order most of the time I shouldn't say that. There's a number of court orders that need to be applied for. It could be for the order absolute, which would result in the lender becoming the owner of the property, or it could more commonly result in an order for conduct of sale. And this basically, an order for conduct of sale is more common because in most cases, the lender doesn't actually want the property. They just want whatever money they can get out of it. In most cases. And so the order for conduct of sale will set out the terms by which the property can be sold to a third-party buyer, and then the lender will receive whatever they're owed. Well, they will receive if there is enough money from that sale to pay the lender what they're owed, the lender will take all of that. And if there is any money left over after that, then the homeowner might have a chance to fight for it. But in many cases, after the sale that's set out by the court, the judicial sale, in many cases, there's not a lot of money left. Usually the lender takes everything that comes from that sale, but there certainly might be exceptions to that. As I said earlier, there's not much that the borrower can do to stop this process unless they are able to redeem the mortgage. If they have a lot of money lying around to pay off the mortgage, well, then they probably wouldn't have been foreclosed on in the first place. So most of the time, if it is possible to redeem the mortgage, it's because the borrower gets some kind of alternate financing. They might go to a different bank, probably pay a higher interest rate, and so that they get a new mortgage on the property. And usually that is the only way that a borrower can redeem the mortgage. Again, there's always the possibility of exceptions, but in most cases, if the borrower cannot get alternate financing, probably there's nothing they can do to stop the foreclosure from happening. And there's not much, I should add, there's not much the tenant can do about it at all, but there are a few options, which I will discuss in just a moment. I wanted to provide some information about how long the foreclosure proceedings might take, because I know that's a question that you might get from an individual who's a tenant in a property that's being foreclosed on, is how long am I going to have here? How long before there's a new owner? How long before I have to move out? And unfortunately, it's a difficult question to answer because every case is a little bit different. In most cases, foreclosure proceedings might take several months or even longer from the first step, which is the lender filing the petition for foreclosure, until the order absolute or the order approving sale, which is when the borrower stops being the legal owner of the property. The most common, I believe the most common redemption period is often 6 months. In other words, after the court grants the order nisi, the borrower usually has 6 months to try to pay off the mortgage. Usually that means they have 6 months to try to find alternate financing. But the process can be shortened. So in some cases, it might only take a few weeks. And the main issue there is going to be how much equity is in the property. So recall, as I said before, equity means the value of the property minus the amount owing on the mortgage. If the mortgage debt exceeds the equity in the property, then the lender will probably apply to shorten the redemption period, because the lender is losing money every month that goes by if the borrower has stopped paying the mortgage. But if, on the other hand, if the property is worth a great deal of money and there's only a small amount owing on the mortgage, well then in most cases, the redemption period would be at least 6 months, because in that case, there's no reason why the borrower should not have plenty of time to try to find some alternate financing or some way to pay off the mortgage, and that is to say, to redeem the mortgage. Next slide, please. Right. So what are a tenant's rights in this situation? And I have included a lot of text in this slide, which I don't usually like to do, but I'm putting it all here because frankly, it's not that important, as I will explain in a minute. And I'll explain what I mean by saying it's not that important. But what I'm saying is not that important is the parts of the RTA and the MHPTA, which say that no order of a court in a proceeding involving a foreclosure is enforceable against a tenant unless the tenant was a party to the proceeding. And there is another rule that has a very similar effect. Civil Rule 21-7 sub 2, and civil rules, for those of you who don't know, is basically the rules that the court, the Supreme Court of BC must follow in all its proceedings. And there is a specific civil rule that applies to foreclosure proceedings. And it says, that's Rule 21-7 sub 2, says all persons whose interest in or claim to the mortgaged property is sought to be extinguished, and all persons against whom any relief is sought must be made respondents. So this is the closest thing you have to laws that actually create rights for the tenant in a foreclosure proceeding. And even the rights that these laws create are pretty minimal. What it means is that a tenant is supposed to be a party to the proceeding, is supposed to be made a respondent to the petition. And that means that the tenant is generally entitled to notification of any steps taken in the foreclosure proceeding. But there are certain things that a tenant has to do to make sure that they get notified about those steps. And I'll discuss that in just a moment. But as I said, the rights that are set out in these rules, in the two acts as well as in the civil rules, are not what I would call, they're not very good rights. They're not easy to enforce, and in many cases, it appears that they're just ignored. And I will explain what I mean in the next slide. So we can go to the next slide, please. So here in this slide, I am referring to a case that was decided by the British Columbia Supreme Court in 2011. And again, I put a lot of text in this slide, and as you'll see when you read it, it is in pretty dense legalese. So I'll try to explain it in just a moment. But in this case, I'll just give you the background. What had happened was a landlord was being foreclosed upon. And after the landlord found out that foreclosure proceedings had started, the landlord rented the property to a new tenant. And to the best of my recollection, I don't have that whole case in front of me right now, but to the best of my recollection, the landlord had not informed the tenant about the foreclosure proceedings. So as far as the tenant knew, they had just signed up for a residential tenancy just like anyone else had, and they were going to be able to live there for as long as their tenancy agreement said they could. Unbeknownst to the tenant, the bank, in this case, a bank called First National Financial GP Corp, was foreclosing on the landlord, a person named Sorotka. And when the foreclosure went through, the tenant was still living in the property. The court had not been notified. It appeared that the people who bought the property through the judicial sale had not been notified. And so there was a question before the court about what should happen to that tenant who was living in the property when it was foreclosed upon. And what the court said, so in the first bullet point here, the court cited an earlier case called Royal Bank of Canada versus Ing, which said that a tenant is bound by the terms of the contract between the mortgagor and mortgagee, and if by the indenture of mortgage, the mortgagor is required to give up possession at any time without demand, the lessee, or the tenant, also must do so in the absence of any fresh tenancy between him and the mortgagee. As I said, that's pretty dense legalese, but basically what it means is if you're a tenant and your landlord gets kicked out of the property, then you're kicked out of the property too. And I am not confident that that is the right interpretation of the laws that you saw on the previous slide, but it is the interpretation that, that the court in BC has upheld. And so in that case, the court went on to say, as it says in the second bullet point here, my decision that the word tenant, and the tenant there was as from section 94 of the Residential Tenancies Act, my decision that the word tenant means a tenancy that is entered into prior to the registration of a certificate of pending legislation does not grant a license to the bank to dig their heads in the sand and ignore the occupation of the lands. Let me go back and explain that sentence. The court refers to the registration of a certificate of pending litigation. That is usually something that happens at the very beginning of the foreclosure process, probably immediately after the bank files the petition for foreclosure, which starts the whole process. So in other words, what this judge was saying, and I think it was actually a master rather than a judge, but for our purposes, it's the same thing. What the master was saying was that the rights that are created by the Residential Tenancies Act and the equivalent right in the Manufactured Homes Act only applies to a tenant if the tenancy began before the foreclosure proceedings began. If the tenancy starts after the beginning of foreclosure proceedings, this decision says that the tenant does not get the benefit of the rights set out in section 94 of the RTA or the equivalent section of the, I keep forgetting the name of the act, the Manufactured Home Act. Now, as it says at the bottom of the last bullet point, the judge went on to say, or the judge or master went on to say, it is good practice for the mortgagee, that's the lender, to establish who is in possession of the land and to notify that person or attempt to notify that person and to advise the court. I have a concern about this decision because I don't think that is merely good practice. I think that is what's clearly required by the laws that I showed you in the previous slide. However, that is not the interpretation that has prevailed. And I'm guessing, I guess in the end, I don't think it actually makes a big difference to the advice that you need to give a tenant in this situation. Because the advice should be either way, the bank is going to find a way to evict that tenant. And so it makes sense for that tenant to start looking for new accommodations as soon as they become aware of foreclosure proceedings. And hopefully they will become aware of foreclosure proceedings right away because they've been named as a respondent to those proceedings. But even if they haven't been named as a respondent, if they have any reason to think that the property is being foreclosed on, the right thing to do or the right advice to give in that situation is probably to say, unfortunately, you need to start looking for a new place to live. So yes, sure.
Sorry, I was a bit slow on the uptake with the question that someone's posed.
Okay.
So I just want, if a person is renting a room in a home, sharing a kitchen and washroom, and is paying month to month, this person is asking if the civil rule gives that person any rights, or if their tenancy just comes to an end at the last month they paid.
Let me go back. Can we go back and look at that civil rule again for a second?
Sorry.
So, can we go to the previous slide, please? There we go. There we go. So the civil rule being referred to is all persons whose interest in or claim to the mortgage property is sought to be extinguished, and all persons against whom any relief is sought but must be made respondents. My interpretation of that is that anybody who is currently living in the property and who the lender wants out of the property needs to be made a respondent. Now, as I'm saying, I'm not sure that that interpretation has been accepted by the courts. And I should add that the civil rule was not considered in that court case that I was talking about a second ago. The court case considered the section 94 of the RTA, but from my recollection, it did not address the civil rules at all. And so there's not a clear answer to this question about who is and who is not protected by Civil Rule 21-7 sub 2. But my interpretation, my own personal answer to that question would be, if someone is legally living in that property, then in order to force them out of the property, the lender has to make them a respondent. But again, the practical advice to give is, even if that person is not a respondent, the bank is very likely going to find a way to evict them from the property at the conclusion of the foreclosure proceedings. So I believe that they do have the right, that I believe that even a person who is not covered by the RTA, let's say a person who's sharing kitchen or bathroom with the landlord, I believe that they still are protected by Civil Rule 21-7 sub 2. But at the same time, I believe that nobody is protected by that rule to any great degree. So, take from that what you will. I think the bottom line is they need to get ready to move out, whatever their situation or whatever their reason is for being in that property. All right, can we go back to that next slide about the court case I referred to? Great, and in fact, I think I have said what I wanted to say about that slide now. Yeah, can we please go on to the next slide? Okay, so now I'm talking about what can a tenant do in this situation? And I think this is maybe my most important slide, and perhaps I should have found a way to highlight that better. But I think this is the main advice that I would give to a tenant who is facing a situation where their landlord's being foreclosed upon. And as it says there, as soon as you have any reason to believe that the lender has started foreclosure proceedings, unfortunately, you got to start looking for a new place to live. There is a good question about how long it's going to be before you are forced out, but in all likelihood, you are going to be forced out. And so I think it is a good idea to be proactive and take steps to do that on your own. A person who is in a difficult position is a person who is on a fixed term tenancy that started before foreclosure proceedings started, because then of course you're not in a position, or you're not easily in a position to end the tenancy on your own. And that means that your control over when you're able to move out, or at least when you're able to stop paying rent, is significantly diminished. I will talk more in a few minutes about the position of a person in a fixed term tenancy, but the long and the short of it is that is a tough position to be in this situation, and there might not be any good answers for that person. But in the meantime, whether you're in a fixed term tenancy or otherwise, there's some other practical steps you can take just to make sure you know what's going on. The first one I would say is, if possible, ask your landlord what's going on. The landlord, of course, should be familiar with the foreclosure proceedings. If they're the owner of the property, they're the one who has the most to lose in those proceedings. Your landlord is not required to talk to you about it. You can't force them to share information with you, or the tenant can't force the landlord to share information about the foreclosure. But I guess my perspective would be, never hurts to ask. And often if the landlord is prepared to talk to you, that is a good way to find out information. But I would also say it is not a bad idea to contact the lender's lawyer. And you can usually, if you have a copy of any court documents related to the foreclosure proceedings, you can usually find the name of the lawyer or law firm on those documents. Most often, you'll probably see it on the last page or the backer of the court documents, but somewhere on those documents should be the name of the law firm that is representing the lender or the bank. And so my advice would be, generally, it's a good idea to email or call them and ask to speak to, in most cases, you should ask to speak to the clerk or the paralegal who is handling the file. You can ask to speak to the lawyer. In my experience, even if you ask to speak to the lawyer, most of the time you're going to get a call back from the clerk or the paralegal. And they're the people who are doing most of the work on the file anyway. They're certainly the ones who are doing the paperwork and filling in the forms. And in most cases, if you're dealing with an experienced, if you're dealing with a law firm that does a lot of foreclosures, the clerk or paralegal is going to be very familiar with the rules and the process, and they can usually tell you just as much as the lawyer would be able to, who is actually representing the lender, would be able to tell you. When you contact the lender's law firm, whoever you speak to, make sure they know that there is a tenant in the property, and the tenant should ask for notice of any steps that are taken in the foreclosure. And now again, just like your landlord, If you're not named as a respondent, and even if you are named as a respondent in some cases, the law firm is not required to share this information with you. My personal experience is that they are generally pretty open about it. Now, there might be other people who have a different perspective, and I'm not sure that my experience is common to everyone. But in my experience, they generally are pretty open to sharing information with affected people about a foreclosure. They don't have much to lose by doing it. And usually, if there is an issue that might come up, if, for example, there's a tenant in the property, the law firm will want to know about that as soon as possible so that they can head off any problems that might arise. So again, you can't force the lender, in most cases, you can't force the lender's lawyer to share information with you. But in my experience, it doesn't hurt to call them and ask. That's often where you're going to get the most accurate information about what's going on in the foreclosure process. If the tenant is not listed as a respondent to the petition for foreclosure, it is important to advise the law firm representing the lender that there is a tenant, that a tenant is in the property. Usually it will result in the law firm taking some additional steps to make you a respondent, or to make the tenant a respondent, and that might create some rights or some opportunities for a tenant to get further information. And I would also say, if there's, it is not a bad idea to follow up in writing to the law firm. I would recommend doing it by email just to make sure that everything goes as quickly as possible, especially if the law firm is not aware of the tenants, is not aware that there's someone living in the property subject to foreclosure, or that there's not a tenant living there. It is important to make sure they get that information, and I would recommend doing it in writing just so you can prove it later in case there is any dispute about what the law firm knew and when. As I said before, I'm not confident that that a tenant in this position has a lot of rights, and I'm not confident that it's going to change a lot if the law firm knows or does not know that the tenant is there. But certainly the tenant has nothing to lose by making sure that the law firm representing the lender is aware that there is someone living there, and that there might be additional steps that they need to take to, well, to represent their client, to represent the lender, I suppose. And again, I mean, in a situation like this, so I already said that fixed term tenants are in a difficult position here, but I think that is probably more relevant to another slide I'm going to get to. So can we please go to the next slide? Okay, so in this slide, we're getting pretty close to giving legal advice. And of course, I'm aware that legal advocates are not in a position to give legal advice. So I'm going to try to tread carefully here. I think it is acceptable for a legal advocate to inform a client that a respondent to a petition has a right to respond to the petition. And the way that you do that, by following the proper channels set out in the rules of court. If a person is named as a respondent to a petition for foreclosure, they may file what's called Form 67, the response to petition form, and they file that with the court. And that is the one way that you can ensure that the tenant is going to receive notification of any hearings and any formal steps taken in the foreclosure proceedings. As you probably know, the court process is very heavy on procedure. There are a lot of rules and technicalities that have to be followed. Form 67 would have to be filed within 21 days from the day when the tenant was served. In other words, when they received the petition for foreclosure. And after that form is filed, it must be served on the lender's law firm by bringing it to their office in person or by registered mail. Now, this is, as I said before, this is an area where you need to tread carefully. There is some risk to the tenant in doing this. It is a very small risk, but there is some possibility that if you respond to the petition, at some point the lender might go after you for costs. And for those who don't know, costs in this context means the court can make someone pay a portion of the legal fees of the successful side in the lawsuit. So in other words, if the tenant does anything that's going to slow down the lender or slow down the foreclosure, the lender might ask the judge or the court at the end of the day to require the tenant to pay some of the lender's legal costs. Most of the time, this probably would not happen, but it's certainly a possibility. And so this is something you need to be careful with. And in many cases, as it says in the slide, it may be better to try to obtain information more informally. by calling or emailing the lender's law firm. And as I said before, in my experience, the law firms that represent lenders are often pretty open with the information that a tenant might be interested in. I can't guarantee that, but that's usually been my experience. And so it might not be necessary to file a form with the court, but it is, I think, something that a person in this position needs to know that it is an option that they have. So if we can please go to the next slide. I have a precedent here for Form 67. And the same document is up, I uploaded to the SCED website, so you can download a Word document that looks just like what you're looking at now. And I've highlighted the sections that would need to be changed depending on the circumstances of your case that you're dealing with. But this is the form that basically tells the court and tells the lender's lawyer that you want, that the tenant, that is, wants to be notified of any steps taken in the foreclosure proceedings. And so if you look on the left-hand side of the page, what I have done in this precedent form, under part 1 and 2, I have said that the respondents to the petition, which in this case are the tenants, Jane and Michael Tenant, are not consenting to and are not opposing any of the orders that the Bank Inc. is asking for. As it says at the bottom of the left-hand page, the petition respondents are taking no position on the granting of any of the orders. They only ask for notice of any steps taken in the matter. And on the right-hand side of the page, there is a place for you to write the name of the person whose affidavit you're going to rely on. And if you're going to prepare an affidavit, and again, I mean, we're getting pretty close to legal advice here and you need to tread carefully, and I would encourage a person, even a legal advocate, to talk to a lawyer about this if they're planning to do it. But you can file an affidavit. If you do, I wouldn't want it to say anything other than, you know, I am a tenant in this property. Here's a copy of my tenancy agreement. It is important not, I think from my perspective, it is important with this form not to try to stop what the bank is doing, because that is when you run into the risk of the tenant having to pay some cost to the landlord. If the tenant just says, I want to be notified, I want to know what's going on in foreclosure proceedings, there shouldn't be any risk of costs. But as soon as you're trying to slow down what the bank is trying to do, there is at least some risk that the bank is going to go after the tenant for costs. And I mean, how that risk might affect the tenant is going to vary depending on the circumstances. But it is certainly something you want to avoid, and you don't want to get a client into that position. I see that when I posted this on the slides, I cut off the part that shows the tenant's address for service. But I do want to emphasize that the address for service is the tenant's, not yours. You cannot go, I mean, as a legal advocate, you cannot go on the record in court. You cannot put your address on here. If this form is being filled out, it's got to be filled out by the tenant themselves. It can't be, or by a lawyer on their behalf, but there shouldn't be anyone else doing it. And there certainly should be no one else putting their address for service on the court record other than a lawyer or the individuals who are directly affected by the court proceedings. In this case, that would be Jane and Michael Tenant. I think that is all I wanted to say about this slide. Can we please go to the next one?
Andrew, Allison posted a tip in chat.
Great.
Saying that if people are worried about a possible foreclosure, that they could search the landlord's name in court services online.
Yes, I completely agree. That is a good way to find out if there have been any court orders or court proceedings started in relation to yourself or the landlord, or yourself or the landlord. So I completely agree with that.
And there's another question here about whether there's a fee to file the form.
To the best of my knowledge, there is not. But as I said earlier, I'm still getting familiar with the process here in BC. So if anyone knows I am wrong about that, I encourage them to indicate that. But there is certainly a fee to start the foreclosure proceeding. But I don't believe that there is a fee to respond to the proceeding if that's all you're doing.
Okay, we'll see what turns up in chat.
So we're on to the next slide now, and I want to include some information about paying the rent, because I suspect that this is something that that your client might ask you about if they are in this position. A tenant's obligation to pay the rent continues just as it always has before until the tenancy ends in accordance with the Residential Tenancies Act or Manufactured Home Tenancy Act. That means that if possible, if the tenant is not in a fixed term residential tenancy, they can take steps to unilaterally end the tenancy, assuming that they have somewhere else to move to. If the tenancy is not ended in accordance with the residential tenants, with the legislation, then it will be ended by court order. And the court order that ends the tenancy will probably say something like, anyone in possession of the property must give up vacant possession. And if that's what the court order says, then the tenancy probably ends on the date when vacant possession must be given. And the order that does that, the order that requires whoever's living there to give up vacant possession, it might be called an order approving sale if the property was sold under the court's direction, or it might be called an order absolute, or it might be called something else. There's no rule that says they have to use one of these specific names. And that's why if a tenant has any court orders, if they've seen any court orders, or if they see them on court services online, as Allison pointed out, it is important to read those court orders carefully, and if possible, to get legal advice in case they might affect some right of the tenants. Certainly, if you see any order that says anything about vacant possession, that is very likely the end of the tenancy on the date when vacant possession must be given. So that is the legal answer to the question about paying your rent. In a more practical sense, as it says here in the slide, if the property is subject to foreclosure, the landlord might not be in a position to enforce the tenant's obligation to pay the rent. In other words, if the landlord has stopped making their mortgage payments, who knows where they're at? Maybe they might have skipped the country for some reason if they've stopped making the payments, and maybe there's no one you can pay the rent to at that point. Well, in that situation, it is possible for the court to direct the tenant to pay rent to someone other than the landlord. And if that's what the court directs, then that is what the tenant must do. But I think that, what was I going to say? I think that the client should consider, whether the tenant that is, should consider whether the landlord is in a position to enforce payment by applying to the RTB. Because in many situations where there's a foreclosure going on, the landlord is probably not in a position to do that. However, if the client may need more time than the bank wants to give them to find a new residence and move out, well, then they better keep paying the rent in the meantime. And if they can't find the landlord to pay it to, they better find someone else to pay it to. And that would usually mean contacting the lender's lawyer and explaining the situation and asking for their direction. Again, that is not, the tenant is not required to do that unless there's a court order that says so. But from a practical perspective, if a tenant wants to preserve their rights their right to live in the property as long as possible, then they might have to take proactive steps to find out where they can pay the rent to if the landlord is somehow vanished, or if the landlord is somehow not accessible or not able to enforce the obligation to pay rent in this situation. I said before that a tenant in a fixed term tenancy is in a difficult position. And I think I'm trying to reinforce it with this slide in that for a tenant in a fixed term tenancy, obviously, as I said before, you're not in a position where you can end the tenancy unilaterally. So you're going to have to keep paying rent until the court says that you must give up vacant possession, even if you already moved out. Now, that is subject to the landlord's duty to mitigate, and it's subject to, well, it gets messy, I guess is all I can say there. And it is not, I think it would not be easy to advise a person in a fixed term tenancy who is facing foreclosure on the property they rent. I think that brings up all sorts of complicated issues, and I sympathize with anyone who is in that position. But I think they have to think very carefully about what might happen to them if they stop paying rent. And well, I think that's what they have to think carefully about. Can we go to the next slide, please? So I wanted to do a section about how to delay eviction. And I want to start by saying it is not easy to delay eviction. I have some suggestions here about it, but you should not count on any of them being effective. And in many cases, the fact is, if the bank wants you out, you're out. And that's all there is to it. The bank, this is a general rule in law that the bank tends to win. They don't always win, but they didn't get to be a bank for nothing. However, if for some reason it is necessary, or if the tenant needs more time to find a new place to live and move out, there are some steps you can take to try to make that happen. First of all, if the tenant is named as a respondent in the foreclosure petition, the tenant may address the court in any hearing regarding foreclosure proceedings. Now, the problem is the tenant might not find out about that hearing unless the tenant filed and served Form 67. But if the tenant does find out about a hearing, one way or another, they should, and if they need more time, they should consider going to court and addressing the court, talking to the judge or the master who is dealing with foreclosure proceedings. If the lender applies for an order that might result in the tenant having to move out, then there's nothing wrong with the tenant contacting the lender's law firm and explaining why they need more time to find a new residence and move out. There's certainly no guarantee that the law firm is going to cooperate with you, but there's nothing wrong with contacting them and asking. But even if they do agree, even if the law firm says, yes, that's fine, I'll give you 2 months instead of just 1, it is probably still a good idea to attend the court hearing and make sure the judge also understands why the tenant needs more time. And again, there's no guarantee. I mean, a judge in a case like this is very much accustomed to doing what the bank wants them to do. So there is no guarantee that just because the tenant says, I'm going to be homeless, I need more time, there's no guarantee that the bank, that the court is going to give you any more time than the lender's law firm wants. But if this is an important thing to get more time before you have to move out, then it is worth it to go to court and explain that situation to the court and see what happens. However, as I said, at the very beginning, the bottom line here is this is a tough thing to stop and you're probably going to have to move. And so the best way, I think, to deal with the foreclosure is to be proactive and to start looking for a new place to live as soon as you find out about the foreclosure. Okay, so these are just some of the, I shouldn't say these are some, these are some reasons why the lender's lawyer and or the court might agree to give the tenant more time to find a new residence. If the tenant only recently found out about the foreclosure and there is a good reason why they could not have found out sooner, for example, they didn't just, fail to check their mail for 6 months, then the lawyer and or the court might be sympathetic to them. However, they're not going to get a lot of sympathy if they stop paying the rent at any point. It will work in their favor if they have continued to pay the rent since finding out about the foreclosure and have generally been a good tenant. If you're, if there's any reason to think the tenant is trashing the property in any way, both the lender's law firm and the court will not have any sympathy for the tenant in that situation. If there is a good reason why the tenant cannot soon find a new residence and move out, then the court might be sympathetic to that argument. If, for example, if there are small children in the rental premises, or if there are elderly or disabled people who are going to have a hard time finding somewhere else to go, this might be a valid reason, but probably only if they recently found out about the foreclosure and couldn't have found out any sooner. If the tenant has just moved into the property, like in the last couple of months, then it's not likely that the lawyer or the judge are going to be sympathetic. But if the tenant has lived in the property for a very long time, that is one more thing that a court might consider in deciding that you should have a little more time to find a new place and move out. And finally, as I've brought up a number of times now, if the tenant is in a fixed term tenancy, which started before the foreclosure proceedings did, I suspect that the court would be sympathetic because the tenant in that case is not in a position where they can just move out and stop paying rent just because they found a new place to live. And so that might be one more factor to consider. I should say, though, that it is not likely that the eviction is going to be delayed unless you have several of these factors in place. And even if you have all of them, there's certainly no guarantee that the court is going to give you as much time as you're asking for. If the lender is asking for vacant possession of the property, then generally it happens pretty quickly. You should assume 30 days. And if you can get 60, that's, you're doing pretty good. And I would be surprised if you get a lot more than that. And this is one of my last slides. And this I just put in here so I could tell the story about how I got to be somewhat familiar with this topic in the first place. And so this is an alternative way to delay eviction, but I wouldn't recommend using it unless there is a global pandemic that has just erupted, or similarly unique circumstances. So I'm going to talk about this case just because I like to talk about it. I think it's an interesting case, and it's how I learned about how foreclosures affect residential tenancies in the first place. In April of this year, very shortly after I started work for Disability Alliance, I represented a paraplegic client who was facing eviction, and I represented her in an application to the BC Supreme Court, because in that case, there had already been an order approving sale. In other words, the court had already approved someone else purchasing the property in which my client was a tenant. The client was being evicted pursuant to that court order because the landlord was being foreclosed on. And that was no fault of my client's. She had been paying her rent throughout the time, but her landlord was a big dummy and made some very stupid mistakes that led the bank to foreclose upon him. And as you recall, as many of you know, at that time, back in April, there was a province-wide moratorium on evictions. However, it only applied to evictions that were ordered pursuant to the Residential Tenancies Act. And this eviction is not. An eviction as a result of foreclosure is made under basically the rules of court. There's nothing, the Residential Tenancy Act doesn't have much to say about it. And so the moratorium had not applied to my client. So we contacted BC Housing, and we were told that they could probably help her find new housing, but it was going to take a long time because there wasn't much this is back in April when nobody could really go anywhere or do anything. So if my client was evicted due to her disabilities, she would have had to move into a long-term care facility. And as you might also recall, back in April, this was around the time of the very first outbreaks of COVID-19, which happened in long-term care facilities. And so when I addressed the court, I cited Dr. Bonnie Henry, who had recently gone on TV and said, long-term care facilities are extremely dangerous places to be right now. And the court was sympathetic to that. And so I applied under the rules of civil procedure, which I put up on this slide. I applied for a stay of execution of the eviction order that was part of the foreclosure proceedings. And we were successful. The court agreed that that my client couldn't be evicted. And in the end, I think the decision was the eviction was stayed until 30 days after the province declares an end to the state of emergency related to the pandemic. And as you all know, the province has not yet declared an end to the state of emergency related to the pandemics. And so my client is still living in the property, even though her landlord was foreclosed upon 6 or 7 months ago now. And I understand that BC Housing is close to moving her now, so hopefully we can close that file pretty soon. But I wanted to include this. I want to say this is not something you can typically do. Generally, the rules of court in relation to stay of proceedings are very narrowly interpreted, and it would be very unusual for a court to delay eviction of a person in these types of circumstances unless there was something extremely unique going on. But of course, last April, there was something extremely unique going on. None of us had ever been in that position before, and nobody wanted my client to end up in long-term care at a time when long-term care was demonstrably a very dangerous place to be. And so that was a win. It was a happy ending. Well, it's not over yet, but it looked like a happy ending for everyone except for the new buyer of the property. And the client, well, as I said, the client is still living in that same property that got foreclosed upon, which is a very unusual thing to have happen, but we're glad that it happened in that case. That's all the story I wanted to tell. Can we go to the next slide, please? Right, and so I'm getting to the very end now, and before we get to any questions, I just want to put up a couple of links to further resources about this topic, about the rights of a tenant whose landlord is being foreclosed upon. The best resource that I am aware of that is specific to BC is the TRAC website, which has a whole section on ways that tenancies can end other than in accordance with the usual legislation. And I would also refer you to a publication of the Legal Services Society. I think it's Legal Aid BC now, but the publication is still under the old name, Legal Services Society, which has a whole booklet about what to do if you can't pay your mortgage. And there's just one page of that booklet that is devoted to what to do if you're a tenant in that position. And so I've given you the link to that website as well as the page reference. It's page 31 of the 37-page document. I believe, if we can go to the next slide, I think it just says questions on it. That is the end of my presentation. I have lots of time. I am happy to take any questions that you might have. And I also encourage, if there are any lawyers or anyone who has expertise on this topic who are here, I certainly encourage you to share your experiences because, as I said, this is only something that I am somewhat familiar with. And if I have said anything wrong about procedure, let's correct the record.
So Andrew, Allison has checked the fee for filing a response. It's $25.
Oh, well, I apologize for that. And thank you, Allison, for pointing that out.
No, that's fine. Although there also is a process to apply to have the court fees waived under
Right.
5 of the Supreme Court rules. So that's one. And there is something in the chat. What does it say? Oh, nothing. Just says if you have a question, post. So we may not.
Fine.
That was really interesting. It was a bit of a sad story until the very end, and then it was great. That's a massive victory.
Yeah, well, I like to tell that story. It was one of my early experiences at the ABC, and it was a fun case to work on. But yeah, as you said, it's not always a happy story. There's not a lot of options the person has in this position, unfortunately, and there is still some advice that they need to hear or some information they need to get. And so people might be dealing with a client in this position, but I think it is important to be honest with them and let them know that, unfortunately, there's only so much that can be done in a situation, and the best proactive step you can take is get yourself out of there as soon as you can. Yeah,
it's not always what people want to hear, but still useful information. One more question turned up. Someone has asked, what is the risk to a tenant if they do not pay rent during foreclosure proceedings and no one has come to collect the rent?
So there is, the risk is that someone might come later to collect the rent. Whether that's likely or not is really going to depend on the circumstances and what happened to the landlord and what is the reason that they're getting foreclosed on. But it's basically the same risk that any tenant takes in not paying the rent at any time. As there is a risk that you're going to be evicted, and even if you're not evicted, there is a risk that someone could come after you, a year later to pay the rent that you were contractually obliged to pay. I would say that the other risk is, as I said before, in some situations, you might have to go before the court and ask the court to give you an extension of time to live in the property. And I'm not sure that you'd be able to get that anyway. But if you haven't paid the rent, it is much less likely that a court would be inclined to give you a break and to give you any more time to stay in the property.
Okay. Another question is about who pays the utility bills during a foreclosure when the bank is trying to sell the home and the former homeowner is no longer in the home, but bills are still in the former homeowner's name. The person asking this recognizes that this isn't foreclosure, but more debt, but they're asking.
Yeah. I would say that, if those bills are in the homeowner's name, it's the homeowner who's legally obliged to pay those bills. I think that the tenant's risk in that situation is that, if nobody's paying them, then the utilities might get turned off, and then obviously it's not a very pleasant place to live. I don't think that there is any risk. I guess it would depend on the terms of the tenancy agreement. If the bills are addressed to the homeowner, then even if there is an agreement between the homeowner and the tenant that says the tenant has to pay them, it's going to be difficult for the utility company to go after the tenant. But it's certainly possible for the landlord to still go after the tenant in that situation. But in a situation where the landlord has just skipped town and is not paying any bills and has disappeared on everyone, I don't think that there's any chance that the tenant's going to be held responsible for those bills. But if the power gets turned off, that obviously is the tenant's problem. So it's a tough position to be in, and you might end up having, I mean, if you want to stay in the property, you might end up having to pay some bills that you shouldn't have had to pay because the alternative is the power might get cut off. Now, I think that probably would not be the power company's first step, but if it looks like there's been multiple notices, then the tenant might have to consider paying those bills if they want to stay there.
And this is a question from up north, so.
Right.
I think that is probably the end. Thank you very much. It's a great presentation. Comments in the chat have said that as well. You're getting compliments on your great case.
Oh yeah, well, it was an interesting case to work on for sure.
Yeah. Okay, thank you, everyone.
Thank you very much.